Just about every day, someone calls us because they've accused a loved one of spousal abuse or domestic battery, and that person now is in jail, and they want to get him out of jail, and they don't want him prosecuted. But what people don't understand is once you make that allegation, once you pick up that phone and call 911, it is no longer you against them. It's the entire state of California against the defendant. And the district attorney's office take these cases very seriously. So it will not be easy for you to withdraw the charges. The question will be, how can you help get the charges reduced or dismissed? And if you do certain things that are truthful, you can help your loved one's lawyer get the charges dropped or get a better result. So what are those things? First of all, in domestic violence cases, it's one of the few cases where a person who is the alleged victim can't be forced to testify. So even if you get a subpoena that's properly served, you do not have to testify, and you can't be thrown in jail for not testifying. That makes the prosecutor's case more difficult. But that doesn't mean by doing that, the charges will be dismissed. In addition to that, you can write a letter to the district attorney and to your clients and to your loved one's lawyer. And you can say, I do not want to proceed with this case. I don't feel like I'm a victim. I don't think my loved one needs battery programs or anger management classes. That can help. But what really is the most important thing is what is the truth. Very often in these cases, alleged victims of domestic violence call 911 and they lie or they exaggerate and they say they were hit and it wasn't self-defense, when in reality it was self-defense. Or maybe the alleged victim had been drinking and maybe the defendant had been drinking and they really don't remember. So a very important thing is if the truth is not what you told the person in the 911 call or when the police came, if the truth is in fact something different, then you could come into our office, if we're representing the accused, and tell us what the truth is. And if that truth is different than what you told the police, that could be helpful to the case as well. So all those factors can help if your loved one has a very good criminal defense attorney who understands the system. Those things can help possibly get the charges dropped. Another thing that I'd like to talk about in this regard is why is it that so many people want to drop these charges? Well, it's because when someone makes the charge, they often don't understand that as soon as they make the charge and the person's arrested, the court is going to issue what's called a criminal protective order, which means that if you've been living with the defendant for 4 years and you have 2 kids and he works and he supports you, well, you're not going to be allowed to have any contact with him. He's not going to be allowed to come to the house or he'll get arrested again. And that is not going to be a good thing most of the times for the families of the defendant. So people don't understand that. It's a major issue and it's very difficult to get a criminal protective order lifted once the court imposes it. So for all those reasons, it's really a good idea to contact our office immediately if you or someone you know has been accused of domestic violence.